Welcome, everyone, to Mental Health Parity, the never ending story. Thank you all so much for joining us. Our moderator for today's call is Jill Brooking. She will be answering the questions you send through the Q&A today as opposed to the chat. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded, and while the new client learning portal is being improved, we will be sharing these recordings in the GetWise Wednesdays emails. If there are any portions that you missed, by Friday, you'll receive an email with a link to the full recording. The PowerPoint slides used in today's presentation will be shared in that same email. Additionally, for those of you who are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In the next 24 hours, I will email the program ID number for you to record and submit to the HR Certification Institute. This credit will only be available to those who listen to the actual webinar, not to those listening to the recording later. Additionally, you must have remained on the call for the entirety of the webinar to be eligible for this credit. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Beth Allen, Vice President and Counsel, and Diane Cross, Vice President and Counsel for NFP's Benefits Compliance Department. We're very excited to have them speaking with us today, and it is my great pleasure to hand the call over to our speakers. Beth, the floor is yours.
Thank you, Leanne, and thank you everyone for joining us today. We're going to talk about mental health parity and what's going on with that. But I know that for some of you on this call, top of mind is the fact that the IRS put out guidance on the ARPA COBRA subsidies yesterday. And so we're still going to talk about mental health parity today, but I am going to let you know that our team is working on some resources that should be going out shortly. And we'll also be having a webinar on Monday to talk about the IRS's guidance. Okay, so I'll just put that out there that we are on top of that, and you can expect to see some information coming out about the webinar that we're going to host Monday. So, mental health parity. We're gonna go ahead and jump in because mental health parity in an hour is a tall task. That's me and myself and Diane there that you see. And as always, the information that we're providing today is informational, and we're not giving you legal or tax advice. So, as a part of kind of what we're going to discuss today, we're going to go through pretty much a review of just the mental health parity requirements that we get from MPAEA, which I guess is the most recent, iteration of mental health parity laws. So we're going to go through what that law requires. And then I also know that the reason that many of you are on this call is because you know that as a part of the Consolidated Appropriations Act of 2021, we basically got this requirement to have an analysis or a report that we can make available on non-quantitative treatment limitations. So we're going to talk about what those are, and we're going to talk about that requirement to have that analysis as well. And then finally, I'm going to talk about kind of some of the practical implications of this and what you have to consider from a compliance standpoint. I will say that mental health parity is a subject where the employers who are on the call, you might not actually have a lot that you can do in this regard, besides potentially holding your insurer or TPA, feet to the fire on this. And so I'm going to try and talk about kind of steps that you can take now to prepare for that new rule that we got from the CAA. So I'm going to go ahead and just jump into the content. Mind you, Jill Brooking is going to be moderating today and will be providing questions at the end when we have that time available. And the rest of the team is going to be answering your questions in the Q&A, so feel free to submit those. So I'm going to kick it off with just an overview of the Mental Health Parity and Addiction Equity Act, or MAPIA. And I think that it's important to kind of realize how we got here, right? And so we call today's segment, the mental health parity, the never ending story, because this is something that's going on for a long time, and I'm starting this particular graphic in 1996 with the Mental Health Parity Act. But keep in mind that we see discussions of mental health parity going all the way back to the Kennedy administration. And we even see some states that were somewhat active with the idea of mental health parity in the 70s, 80s, and early 90s. And so this is not necessarily something that's new, but from a federal standpoint, we've gotten the most guidance as it pertains to parity in the last 20 something odd years. And so the Mental Health Parity Act of 1996 became effective in 1997. It amended ERISA to talk about this idea of parity. It also, applied to employers that are over 50, but it didn't actually add substance use disorder. So that's something we see come on later. So it literally was just talking about basically a mental health or behavioral health concepts. Um, and so then, some time passed by. We had a little bit of action from the DOL. The Bush administration also kind of put out some additional guidance on the idea of mental health parity and did some reports that we saw go through Congress. And then in 2008, we got the Paul Wellstone and P. Domenici Mental Health Parity and Addiction Equity Act. And so that is MAPIA. That's what we're going to be talking about today as far as the requirements that are going to apply for mental health parity. And then since then, as you can see, we've got a number of like rules that have come through from the DOL, IRS, or HHS on this subject. And it's kind of interesting because the DOL, the guidance that they've put out on this really has kind of followed what happened between the DOL and insurers on this subject. Okay. And so I actually was at the Department of Labor from 2009 to 2014 when we first had MAPIA come out. And in those beginning years, it was kind of really hard for the DOL to kind of get compliance on mental health parity. And so a lot of the guidance that we have received since then comes from what the DOL experienced between 2010 and 2014 in trying to get this issue taken care of with insurers. Okay, and so just keep that concept in your mind that everything that we have gotten kind of in the last several years has come as a result of what the DOL ran into when they tried to kind of get insurers to comply with mental health parity. So, going into just an overview of the law, it's important to kind of just give you an idea of what the law says and what it requires. And I think the first thing to point out is that it doesn't actually require group health plans to provide mental health benefits. So, that's actually not something that we get from MAPIA. It is just written to say that if the plan does offer mental health and/or substance use disorder benefits, then those benefits have to be provided in parity with medical surgical benefits. Okay. And I'm going to describe a little bit later what it means to be in parity as it pertains to financial requirements, treatment limitations, and lifetime and dollar limits. But keep in mind that this is really just if the plan offers it. Now, some of you in the small group market will have to offer mental health because is an essential health benefit. And so we kind of have that distinction that comes out there. But just keep in mind that the federal MAPIA statute doesn't actually require groups to cover mental health benefits or substance use disorder benefits. Now, mind you, before that, what we saw was that, with mental health benefits, the plan might actually be written to limit how much, a person could actually receive benefits for mental health, right? So we saw visit limits and we saw certain, designs where you could only, let's say, go to in-network mental health providers. And so MAPIA kind of comes along and says, well, no, you can't do that if you don't do it also on the medical surgical side. So to start off, who must comply? And it's kind of interesting because we do still run into groups that don't quite realize that this is actually pretty broad and who it applies to. It's going to apply to most group health plans and the insurers, the fully insured plans for sure, who are offering medical surgical benefits and mental health substance use disorder benefits. Okay, so that's going to be both fully insured plans and self-insured plans, and it's kind of different from a lot of the things we have with ERISA in that there's not actually an exemption for church plans. We do have an exemption for non federal governmental plans that are self funded, but they actually have an opt out process. So they actually have to go to CMS and say, we're going to opt out of that. Okay. The other place we see kind of a large exemption is for employers that have 50 or fewer employees. Basically, they could be considered kind of too small to have to comply with MAPIA. But as I mentioned with the last slide, because of the ACA requirements surrounding essential health benefits, a lot of times you're going to find that the small plans do offer mental health and substance use disorder benefits. And they end up kind of indirectly being subject to the federal mental health parity requirements because of that. Okay. And so keep in mind that even that smaller employer exemption doesn't quite function the way it used to pre ACA. So then once we kind of realize, okay, mental health parity applies to all of these different employers, what exactly does that mean? And when we think about what mental health parity means, it's this idea that the group health plans and insurers that offer coverage, and this is going to be both in the group health market as well as the individual health market, have to make sure that basically financial requirements and or treatment limitations that are imposed on mental health and substance use disorder benefits are not more restrictive than the predominant requirements that are applied to substantially all medical surgical benefits. Now, that's a lot of words, and you see on the screen where I have bolded some of them to kind of make clear what the standard is. But I'm going to do an example just so that you understand how this works, okay? But you can see just from this slide that figuring this out is not necessarily an easy thing to do. And when you see terms like substantially all and predominant, that's generally going to mean that some math is involved for some of this analysis. Okay. And so it's not one of those easy things that can be done. And so generally, you're going to have other entities that are involved in helping you do this analysis. So, as it pertains to parity and how parity is required, it's specifically kind of the law has three different mandates. Now, that first one of this requirement that group health plans cannot apply annual or lifetime dollar limits for med surge benefits that, or they can't apply those to mental health benefits if they don't apply to medical surgical benefits. That basically is kind of I'm not gonna say it's a non-factor, but because of the ACA, you're not supposed to have annual or lifetime dollar limits on anything that's an essential health benefit, right? And so you don't run then into a lot of mental health or substance use disorder benefits having an annual or lifetime limit because of the fact that generally we just don't allow annual or lifetime limits on essential health benefits. Now, interestingly, that discussion then has to go into, well, what is the essential health benefits? And that's where, for example, if we have self-funded plans, they're going to pick a state benchmark that is going to say what the actual essential health benefits are to which those annual or lifetime dollar limits cannot be applied. Okay. And so that is part of that, analysis. But I'm not going to go into a lot of detail on that because, like I said, the ACA has just made it to where we're not really supposed to have those limits. But keep in mind that the benchmark that a self funded plan chooses is going to affect that. And if it's not a self funded plan, then, the fact that or excuse me, state law on what essential health benefits are is going to affect that. But what I will talk about today is the other two requirements, which are parity as to financial requirements and quantitative treatment limitations, and then parity as to non quantitative treatment limitations. Now, that parity as to financial requirements and quantitative treatment limitations, we've had that kind of figured out for a number of years now, right? So, as I mentioned, the DOL kind of fought it out with insurers from 2009 to 2014. Specifically on quantitative treatment limitations. And then we saw them turn their sights more on non quantitative treatment limitations and put out more guidance on that. And so I'm going to discuss the financial requirements and quantitative treatment limitations examples and kind of how you look at that. And then Diane is going to go into non quantitative treatment limitations as a lead up into what the CAA did in requiring a report on non quantitative treatment limitations. Now, mind you, I think I'm done with saying non quantitative treatment limitations. So from here on out, it'll be NQTLs, but that's what I'm talking about. So, when we look at parity as the financial requirements and quantitative treatment limitations, that's a long and involved way to say that basically, if you see a numerical or numbers or money based requirement on benefits that is likely going to come, it's going to have this rule apply, if you will. And the idea there is that again, the benefits and the way that the financial requirements or treatment limitations are applied to mental health can't be more restrictive than what is applied to medical surgical benefits. And for those purposes, the test is going to look at kind of six classifications. Okay, so those six classifications you see there, inpatient and network, inpatient out of network, is how you would break up those different benefits to decide if they're in parity. And so, for as an example, when we look at mental health benefits that are inpatient in network, those are going to be judged against the medical surgical benefits that are inpatient in network when we're deciding whether or not it's in parity. Okay. Now, mind you, these rules are also going to mean that you can't really have separate cost sharing requirements that are only applicable to mental health or substance use disorder benefits. I think that this has become a little bit easier because of the fact that the SBC, right, lays out a lot of the cost sharing. And so we kind of know straight up if you see some extra cost sharing requirement that applies on mental health, that's going to be a problem. And so we don't generally run into that. However, It also means that the financial requirements that are imposed, such as deductibles, copays, coinsurance, and out-of-pocket maximums, should also be in parity. And interestingly, that's something again that the DOL dealt with pretty much out the gate. But I'm still seeing some insurers who might have certain financial requirements that, on the face of the documents, appear not to be in parity. Okay. And then you're also going to have certain, let's say, numerical visit numbers that might apply that are going to also apply here, as is the idea that, if out of network benefits are provided for medical conditions, they also have to be provided for mental health, substance use disorder expenses. And so let's kind of break down this rule just because, as I mentioned, it's a lot of terms, okay? But the rule kind of explains how the test works, okay? And so the basic rule is that a plan or insurer may not apply any financial requirement or quantitative treatment limitation to mental health benefits in any classification that is more restrictive than the predominant financial requirement or quantitative treatment limitation that is applied to substantially all medical surgical benefits in the same classification. Okay. So it's good to kind of define the terms there. When we see that term substantially all, um, it's basically the idea that a certain financial requirement is considered to apply to substantially all medical surgical benefits if it applies to at least two-thirds of all of the medical surgical benefits in that classification. Now, interestingly, in application, if it does not apply to two-thirds of all medical surgical benefits in that particular classification, then you can't actually impose it on mental health, right? So it actually has to apply to two-thirds. And then once we get to that first part of the test being met, to where, let's say, the financial requirement does apply to at least two-thirds, then we have to go back and say, okay, well, what is the level of it? And when we start to talk about levels, that's when we kind of further break down numbers. And I think the easiest example is copays, right? Because when we talk about the level of a copay, it could be $35 or it could be $50 or $75. But basically, what happens after that two-third test is met, and we've decided, okay, this particular financial requirement does apply to substantially all medical surgical benefits, then we say, okay, at what level is the predominant level? And the predominant level is going to be the level that applies to more than half of the medical surgical benefits. Now, mind you, a lot of you, like me, may not love math. I don't love math. That's why I became an attorney instead. And so this is difficult, but it's really a test that is going to involve kind of some actuarial work and looking at the actual dollars that are spent under the plan, right? Because it's not just a matter of kind of the benefits that are offered and what they would presumably look like or what one person would have access to. It's really all of the benefits that are paid out under the plan. And so that's why, if you have someone who is going to test this for you, it involves generally actuaries going in and looking at the benefits that are actually paid under the plan to determine, what particular treatment limitations or financial requirements were applied to substantially all the benefits. So I think it's helpful to do an example, okay? And I'm going to try and go through this fairly quickly. But let's say that you have a plan that applies to different copays to some of its outpatient in network medical surgical benefits, right? So let's say that for certain benefits, it's a $30 copay, but it might be a $40 copay or something along those lines. What copay can the plan apply to outpatient in network mental health or substance use disorder benefits? Okay. The first step is to look at that substantially all test, right? And so basically, the plan is going to look at the benefits that were actually paid under the plan, and they decide that basically the plan's payments are about $50 million. Okay. The plan projects that plan payments for the benefits that are subject to a copay is $40 million. So that means $40 million of those $50 million of benefits were subject to a copay. All right. Because that 40 million is greater than two-thirds of the 50 million amount, a copay can be applied to mental health substance use disorder benefits. Okay, so we start there with whether or not that large chunk or two-thirds of the benefits paid under the plan had a copay assessed on them. And then if they did, then you can apply a copay for mental health benefits. But then the next step says, okay, now that we know that a copay can be imposed, how much is that copay, right? And so let's say that the plan applies a $35 copay to some of its medical surgical benefits and a $20 copay to other benefits. Using that same kind of test where you're looking at the benefits and how they've been paid, the plan projects that costs of $25 million for the benefits have a $35 copay applies, and for 15 million of the benefits, a $20 copay applies. And so in this regard, the 35 copay is going to be the $35 copay is going to be the predominant copay because it applies to more than half of the medical surgical benefits that were actually subject to a copay. And so when you look at those two tests together, kind of the conclusion is that the plan can impose any level of a copay for that outpatient in-network mental health substance use disorder benefits that is no more restrictive than the $35 copay. When we talk about what restrictive means, the idea is it can't cost more, right? So you could not do a $40 copay or a $50 copay or a $65 copay. Now, sometimes we get the question, could they choose to charge a $25 copay? And that's kind of like reverse, I guess, right? So it's not actually more restrictive, it's actually less restrictive, which Mapia doesn't have a problem with, right? But that kind of goes to the idea that what Mapia is trying to deal with is the stigma involved with people getting mental health. So if you actually, or mental health treatment. So if you actually make it easier for them to get mental health treatment, that doesn't actually run afoul of Mapia, okay? But generally, that's how this works. Now, I know a lot of your heads are spinning. And that's why I mentioned that this particular testing is usually done by actuaries or the insurer who has access to the data that's even going to be able to tell you kind of how much in benefits were paid under the plan, how much of it was subject to a copay, and things like that. Now, parity as to non-quantitative treatment limitations gets easier, okay? And I say easier in that not as many numbers, if you will, are involved. You're not having to look at it that way. But the rule does basically come out to where a plan cannot impose an NQTL on mental health or substance use disorder benefits in any classification, unless basically the processes, strategies, evidentiary standards, or other factors that are used um, in applying the NQTL are comparable to and are applied no more stringently than the processes, strategies, evidentiary standards that are basically applied to medical surgical benefits. And so this looks different. And like I said, Diane is going to talk about this a little bit more. But generally, what it's going to mean is that, again, a plan is not going to be able to have, let's say, these separate treatment limitations. And on this one, it's a little different because, like I said, not as many numbers. It's really just going to more be like, okay, what does it take to get the benefit? And if that is different, then that could potentially be a violation of the NQTL, rules. But really, the focus should be kind of just on making sure that there's not really these arbitrary limits put in place to people receiving those benefits. And so, with that, I'm going to turn it over to Diane to start talking about non-quantitative treatment limitations.
Thanks so much, Beth. So now that we have an understanding of the Mental Health Parity and Addiction Equity Act, what parity means, what it looks like for the financial and quantitative limitations that you just reviewed, I think it's helpful to take a deep dive into what these non-quantitative treatment limitations really look like. What does it mean? How are they defined? So I'm with you. I'm ditching straight with the acronym because it is a lot of letters to say. So we're going with not NQTLs. So next slide, please. So so let's review the general rules that Beth went over. And what she was saying is that a plan cannot impose NQTLs for mental health and substance abuse disorders in any classification unless certain conditions are met. So as it was mentioned, a plan cannot impose those NQTLs on the mental health substance abuse benefits in any classification unless those processes and other factors as described are used in applying the NQTLs to the mental health benefits as they are compared to medical surgical benefits, right? So a plan can have no separate treatment limitations that are applicable with respect only to mental health benefits. So practically speaking, as we're saying, we're looking for no arbitrary limits placed on the mental health substance abuse disorder benefits. So what are these NQTLs that we keep referring to? The regulations provide a list to help make it helpful, but a tip here is that this list is not exhaustive, but it gives a good idea. And I will say for many, this isn't as straightforward as the financial and quantitative treatment limitations. So after we go through these, this list, we'll we'll talk about this through examples that might be better digested for comprehension. So we have medical management standards, formulary design for prescription drug coverage, standards for provider admission to participate in the network, plan methods used for determining usual or reasonable charges, and those fail first policies, or commonly referred to as the step therapy protocols, so refusal to pay for higher cost therapies until it can be shown that a lower cost therapy is not as effective. Exclusions based on failure to complete a course of treatment, new tier design, or restrictions based on geographic location. So these are what we're referring to when we're talking about the NQTLs. And it's important to grasp this because, as we talk later in the presentation, the Consolidated Appropriations Act created this comparative analysis requirement on these NQTLs. So next slide, please. And I do want to reiterate, though, that this list isn't exhaustive. There are several other examples, so I just want to make sure that while we have some guidance that that's not an exhaustive list. So here's a good, simple, quick examples of where a plan design factor translates into an NQTL. And let's look at some common ones. So treatment limitation based on medical management. So the NQTL there would be exclusion based on medical necessity or appropriateness. Another NQTL is pre-authorization review requirements. When dealing with step therapy requirements, so having an exclusion of a higher cost treatment until the lower cost treatment is utilized and not effective. Developmental disability exclusion or bipolar disorder exclusion. Again, these are just examples. So that would be a treatment limitation based on type of disorder. Let's say nutritional counseling is excluded. That would be a treatment limitation based on the type of treatment, or residential treatment limitation or out-of-pocket network inpatient treatment exclusion. And that would be a treatment limitation based on type of setting. So here, really, it's just taking that list of what we went through and trying to solidify understanding on what exactly those non-quantitative treatment limitations look like. And as you can see here, these plan design factors are common. We do see these. So next slide, please. Oh, all right. So I find that understanding of the NQTLs is better done through explanations and examples. So over the next two slides, we're going to go through some of the common NQTLs and examples of where parity is in compliance and when it is not. So when we're dealing with coverage for outpatient visits and inpatient hospital stays, a quick example is if the plan classifies care in a skilled nursing facility or rehab in hospitals as inpatient benefits, then the plan should also do that for covered care in residential treatment facilities for mental health, substance abuse, disorder benefits as an inpatient benefit. Okay, another example, if a plan treats home health care as an outpatient benefit, then any covered extensive outpatient mental health, substance abuse, disorder services and hospitalization must be considered outpatient benefit as well. Okay. Penalty for failure to obtain prior approval for treatment. So an example here is where a plan requires prior approval that a course of treatment is medically necessary for outpatient, in-network, medical, surgical, mental health, and substance use benefits. So here's where we're seeing a requirement specific to a classification of outpatient in-network benefits. But for mental health treatments that do not have prior approval, no benefits paid. But for medical surgical treatments that do not have prior approval, there will be a 25% reduction in the benefit that would be paid otherwise. So as you can see here, there's not parity because the penalty for failure to obtain prior approval under those mental health, substance abuse disorder benefits isn't comparable to medical surgical benefits. This would likely not comply with the non-quantitative treatment rules that Beth reviewed. Next slide, please. So let's look at requirement for prior authorization. So here, for example, you have mental health substance abuse disorder benefits. The plan requires prior authorization from the plan's utilization reviewer that treatment is medically necessary. However, the plan does not require prior authorization for any medical surgical benefits. Similar here, because the plan applies an NQTL limitation to mental health and substance abuse disorder benefits that it does not apply to those medical surgical benefits, this plan would not comply with the non-quantitative treatment rules. So there's no parity there. And then with utilization review, an example here is that a plan generally covers medically appropriate treatments, but does require prior authorization from the plan's utilization reviewer for all inpatient treatments. But in practice, the inpatient benefits for any medical surgical benefits are approved for 7 days, and after which treatment plan must be submitted by the patient's attending provider or approved by the plan. But when you look at the mental health substance abuse disorder benefits, they're routinely approved for only 1 day, after which a treatment plan must be submitted by the patient's attending provider or approved by the plan. So while you can have differences in prior authorization practices that reflect clinically appropriate standards of care, an across-the-line board of application of a stricter prior authorization requirement for benefits for mental health and substance abuse disorders is not permitted. So those are a few examples that I don't think it's very helpful just to state what NQTLs are without really peeling back the layers a little bit and seeing how they unfold in plan design options. Next slide, please. So with that, now we have the whole understanding of Mapia. Consolidated Appropriations Act of 2021 produced some requirements as it relates to Mapia compliance. So next slide, please. As you may have heard, the CAA requires a comparative analysis requirement. This is ideally showing that process, those strategies, the evidentiary standards, or any other factors used in developing and applying those NQTLs, that they're comparable and applied no more stringently to the mental health substance abuse disorder benefits than to medical surgical benefits. So what does this mean? As of February 10th of this year, the comparative analysis and other specific information has to be available to an applicable state or federal agency upon request. So this logically begs the question, what is a comparative analysis? I said the term a few times now. As it stands, the CAA doesn't define comparative analysis, but we do have some direction from agency guidance that provides clarification. So here, the bottom line takeaway is that a comparative analysis is required for each NQTL, and it must be sufficiently detailed and reasoned to demonstrate whether the process or other factors used when developing and applying these NQTLs, that they're comparable and applied no more stringently to mental health benefits than to medical surgical benefits. And the plans will have to support any NQTLs and show compliance with Mental Health Parity and Addiction and Equity Act rules. Next slide, please. So what is that guidance we have on this comparative annual analysis requirement? We have linked later in this presentation to DOL FAQs that answer some questions on the Mental Health Parity, Addiction and Equity Act, as well as the CAA requirements as it relates to this comparative analysis. And so we get that the analysis has to include a robust discussion of 9 different elements. And that would be a clear description of the specific NQTL, plan terms and policies at issue, identification of specific mental health, substance abuse disorder, and medical surgical benefits to which the non-QTL applies within each benefit classification, Identification of factors, evidentiary standards, or resources or strategies are those processes used in consideration of the design of the application of the NQTL. And this should explain whether any factors were given more weight than others and the reasons for doing so. And that would include an evaluation of any specific data used in the determination. It must also include precise definitions used in supporting sources. So before we carry on with the next slide, as you can see, it is a very detailed comparative analysis. So next slide, please. And to continue on with those elements where the guidance encourages a robust discussion of, we need an explanation of any variation in the application of a guideline or a standard used by a plan when it relates to mental health and substance abuse disorder benefits and medical surgical benefits. Describe the process and factors used for establishing each variation. If the application of the NQTL turns on specific decisions in administering the benefit, that the plan needs to identify the nature of those decisions, who the decision makers were, when the decisions were made, and the qualifications of the decision makers. If the analysis relies on experts, the analysis should include an assessment of each expert's qualifications, a reasoned discussion of the plan or issues findings and conclusions as to the comparability of the processes, strategies, etc., and sources identified with each affected classification and their relative stringency, and then the date of the analysis, name, title, position of the person who performs the analysis. Okay, next slide, please. All right, so with all of that, and we realize this is a lot of information and a lot to digest. So we have Mapia, we have its requirements, we have the CAA that has come out and effective February 10th, 2021. We have this comparative analysis requirement. So what's the next steps? What are we supposed to do and how are we to comply? If an agency or if an employer is requested to provide a comparative analysis, the overview process is that the agency will review, and if they find that the analysis indicates a violation of these rules, a plan has 45 days to provide additional information to correct the violation. If the agency makes a final determination that the plan is out of compliance, the plan will be required to notify enrollees within 7 days of that determination. In addition, the DOL reports its findings to applicable state officials and to Congress, and I believe the report is made available to the public. And this will happen on an annual basis. Further, plan participants are also entitled to receive the plan's comparative analysis and supporting information should they request it. Okay, so the golden question here is who's responsible to comply? For fully insured plans, the employer as plan sponsor and the carrier share responsibility. But for self-insured plans, the employer as the plan sponsor is responsible. Now, a TPA can be utilized, but as with many other rules, the ultimate responsibility will lie with the employer plan sponsor. So that being said, there are a few things we want to point out. Next slide, please. That will be helpful as we're navigating this new requirement. The DOL did identify in those FAQs that I referenced earlier 4 NQTLs where enforcement efforts will be focused. Prior authorization requirements for in-network and out-of-network inpatient services, concurrent review for in-network and out-of-network inpatient and outpatient services, standards for provider admission to a network, including reimbursement rates, and then out-of-network reimbursement rates, including plan methods for determining usual, customary, and reasonable charges. Okay, so I want to pause here to just because the DOL identified these 4 NQTLs where enforcement efforts will be focused, the plan should still perform and document an analysis for all NQTLs imposed. But it was guidance specifically provided in the FAQs where those 4 are the enforcement efforts, if you will. So it's worth noting and keeping in mind. And that may be when completing the comparative analysis where the efforts start, perhaps. So what are some takeaways? Next slide, please. On some do's and don'ts. So the joint FAQs that the DOL provided in conjunction with, I believe, HHS and the IRS, but they provide some guidance on what will and won't work for the comparative analysis requirement. So conclusory or generalized statements without specific supporting evidence and detailed explanations are insufficient. What is also insufficient is productions of a large volume of documents without a clear explanation of how each document is relevant. So a document dump, if you will, not sufficient. Plans should be prepared to provide documents that support the analysis and conclusions of their comparative analysis. The DOL does specifically state that necessary supporting information may vary depending on the type of QTL and the processes utilized. So listed examples include records, documenting, and QTL processes would be details on how NQTLs are applied to both med-surg and mental health substance abuse disorder benefits, claims processing, policies and procedures, samples of covered and denied mental health substance abuse disorder and medical surgical benefit claims, stuff like that could be supporting. So in essence, just to be duplicative here, but to really hammer this home, what we do want to do is prepare a detailed and thorough analysis. We want to follow the content requirements provided by the guidance, include data, processes, and strategies, and provide evidence and well-reasoned conclusions. We do not want to be vague. We do not want to offer documents to review instead of a detailed report. We do not want to disregard the content requirements. We do not want to provide an explanation without comparison to the med-surg benefit. And then we certainly do not want to assume that the carrier or the TPA is compliant. So with that, I'm going to pass it over to Beth to talk about some practical application.
Sure. Thank you, Diane. And I'm going to leave it on this slide for a second because we've, spent a good amount of time going through what the requirements are. And I want to take this time to kind of talk the real deal with you all about this requirement and just explain how we got here and kind of what you're seeing from the standpoint of how the DOL kind of came out with this guidance. Okay. So I explained kind of when the law went into effect and kind of what the DOL has put out since, but I'm going to explain a little bit of the backstory of how this really played out. Okay. So we got Mapia as a law, and insurers, obviously, at that point, had any number of quantitative treatment limitations and non-quantitative treatment limitations that had been imposed forever, right? They didn't necessarily just want to take them all out. Okay. So the DOL started catching plans that had these limitations and went to the employer and said, "Hey, you have these limitations." The employer said, "Well, we didn't put them there. It's not like we wrote our policy, right?" So they didn't specifically say, "I want the copay for mental health to be $50, whereas the copay for regular primary care visits are $25." They're not the ones that decided that, right? And that's even with self-funded plans where the employer usually relied upon the insurer that was serving as the TPA to determine what those benefit parameters were. Okay. So obviously, if the DOL reviewed a plan like that and the employer said, "Well, we didn't pick it, and we don't necessarily have the power, let's say, to go in and remove that from the plan," the DOL then had to deal with the insurer, right? On the first iteration of all this, the insurers kind of came back as a group, and forgive me if there are any insurers on this call, but they kind of came back quickly with the DOL and said, "You don't have jurisdiction over us." And so they kind of had to fight about the authority of the DOL to come after insurers for this for a number of years, right? They kind of got that settled through a series of final regulations that we saw. And then the DOL came back and said, "Okay, I want you to change this in the plan." Okay. So then we saw insurers say, "Well, we can't necessarily just change things because under state law, we can't necessarily change our policies without permission from the state." Right. So then the DOL actually got memorandums of understanding from state insurance agencies to say, no, if you do have a problem and you are not compliant with federal MAPIA, you need to change that policy to come into compliance. And this is also where we saw a lot of states pass their own state version of MAPIA to make it very clear that you cannot offer a policy in our state that is going to provide mental health benefits in a way that is not in parity. Okay. So then, once that got settled, the DOL came back to the insurer and said, okay, you have this in there on the face of the document. It does not appear to be in parity. And the insurer said, well, it is. So the DOL said, prove it. And then what the insurers did was often dump thousands and thousands of documents on the DOL to basically say, hey, this is why it's not in parity. As you can imagine, the DOL did not want to go through thousands and thousands of documents to figure out what the insurer was saying, right? On the quantitative treatment limitation side, it's a little easier because it's just math, right? So the DOL just said how much in benefits were paid, how much of that in the example I gave had a copay apply, and they could do the math. But on the non-quantitative treatment limitation side, as you can expect, a data dump of thousands and thousands of documents did not actually give them the information they needed to determine that the insurer had actually done something to analyze those benefits and make sure that they were in parity. And so then, fast forward to the CAA, what we see is a congressional rule or something that we get that comes out of Congress, who does have authority over insurers, that basically says, well, we don't want that anymore. So what you need to do is give us a specific report. Okay. And so that is where we are now. And I think the number one question I got from people often was, well, CAA came out in December. How could they make it effective in February? That's so soon. How could they expect people to be able to have that report by then? And the way I explained it is that remember that if you have things that are in your plan that are not in parity, this analysis should have been done before those terms were put in the plan, right? Like they shouldn't have gone in there under MAPIA unless someone knew that they were in parity. And so the problem we're having now is that a lot of you employers are saying, okay, well, what do I do? How do I come up with this analysis? And the insurers do not already have it, right? And even if they did, it may be on the quantitative treatment limitation side, but not on the MQTL side. And so we're all somewhat scrambling trying to figure out how to address this. Okay. So that is like the never ending story aspect of it. And with that kind of in mind, I'm going to just go into some compliance considerations and somewhat employer takeaways. And hopefully I'll finish this with a little bit of time for questions. Now, mind you, as far as enforcement of MAPIA is concerned, we're dealing with a few different agencies in this regard. So, the Department of Labor, Health and Human Services, and specifically CMS is generally going to be concerned with MAPIA, as well as the Department of the Treasury or the IRS, all kind of share joint jurisdiction over MAPIA. And generally, it's kind of interesting because we wanted to kind of do a slide and say, okay, well, what are the penalties if you're not in compliance? But the way that, and I'm pretty sure there's some statutory penalties that are in there, but the way that this works generally is that if the DOL comes out and they find out that you don't have, or let's say you have some like limitation that is not in parity, then fixing that involves re-adjudicating those claims. So it's not just a matter of, oh, you just pay some $100 a day penalty times however many days you had the mistake. It's that if you imposed a higher copay than you should have on someone who received mental health treatment, you will go back and you will give them the difference. Okay. So as you can imagine, that becomes a very big correction. And a lot of times it's something that the insurers have had to get involved with. But again, that's also why we saw a lot of the states also promulgate kind of the same rules about how the mental health parity rules apply. Now, I think, as I've already mentioned, the elephant in the room here is that employers usually did not decide on these terms and cannot fix them alone, right? And likewise, changing plan documents is not as easy as just cutting and pasting, right? Because you have to make sure that the actual operation of the plan lines up with what you put in the document. And as I mentioned before, state insurance law can somewhat put a wrinkle in that process, but the DOL has worked with states and with insurers to kind of make sure that that doesn't happen, to where if there is now a parity issue in a document, insurers can usually fix that. Okay. Now, mind you, the DOL put out a number of helpful resources. So there's a warning signs document that they put out a number of years ago that kind of explains some of those NQTLs. They have a self-compliance tool. So if you wanted to go into your own plan and review it for compliance, you could. And then, as Diane mentioned, the FAQs on implementing the CAA Mapia provision about non-quantitative treatment limitation reports or analysis reports is also something that you can look at. But to be honest, as a takeaway, um, it's kind of interesting with the non-quantitative treatment limitation reports because the DOL has already said that kind of how they're going to enforce that is they're going to go out and they're going to choose 20 plans, and then they're going to review the CAA analysis and determine like if the analysis is good enough. They're also supposed to put out regulations that talk about what that analysis should look like. But if I go back in history to what this has looked like in the past, they might even wait until they start seeing some of them to do those rules. And so I think that, if you have someone or an insurer who's saying, well, we're holding our breath to see when the DOL comes out with guidance, that's not necessarily a good thing to do because it was effective in February and they may very well not come out with guidance before you are expected to have one or are asked for it from a participant, right? And so you would need to have it. Now, mind you, I think from the standpoint of employers, you're stuck between a rock and a hard place, right? Because you want to be compliant, but the reality is that you don't have the data, right, to prove whether or not the plan is in parity. Even if you were to go into your plan and sit down and identify all the non-quantitative treatment limitations, and go to the insurer and say, "Hey, remove them," the insurer might push back, right? And even if you did that to maybe make yourself more compliant or have a better chance of being compliant, you're still somewhat at the mercy of the insurer of getting that done. Now, I do think that employers have, a little bit of power there to go and say, hey, you know, these NQTLs exist. Can you provide us the analysis because they're in our plan? And if the insurer can't, then again, there's a concern there because it's like, well, you have to have this analysis if we have this NQTL, right? So we can take it out, but if you don't want to take it out, then provide us the analysis, right? I think the biggest thing to know, whether you're fully insured or self-funded, is that you want to have that conversation with your TPA and insurer. And your account teams at NFP, are having these conversations with insurers. We're trying to see kind of how they're going. And I will not lie. I will say that it's moving much slower than I think a lot of us would like it to move. But just keep in mind that I think that even if you do end up being one of those 20 plans that the DOL chooses, at that point, it will be imperative for you to at least have had a conversation. Okay. Because no matter what, by the time the DOL closes their case, you're going to have one of these, right? It might mean that you just take out all the NQTLs because it's easier and because the insurer that you're dealing with doesn't want the spotlight on them. But just keep in mind that, you know, I think the conversation and knowing that this requirement exists is the most important thing that you want to consider in the coming months as the insurers figure out how they're going to address this issue and help employers provide this analysis. Okay. And so, with that said, we have about 5 minutes for questions, I believe, which is pretty good. And I'll go back to this page. Jill, have you seen anything that you would bring up as far as kind of questions? We didn't get a whole lot. This was a shy group today, but mental health parity is kind of difficult.
Thank you, Beth. Yeah, we didn't get a lot of questions, but I think it's one of those situations where people don't know what to ask. Yeah. And but kudos to you and Diane for taking on this complex topic, and kudos to all of you that are on this call. So yeah, I have 2 questions right now for you, unless something else comes in. The first is, so just to confirm, are you saying that I I don't have to submit any report right now online or to something unless the DOL or a participant asks me? That's when I actually have to send my report somewhere, but we all should be prepared in case we are requested upon.
Yes, that's exactly what I'm saying, right? And so they made the effective date or the date that you're supposed to have the report, February 10th or whatever that date was, right? But theoretically, it doesn't come up unless someone asks you for it. Now, what I caution employers about this, okay? is that the DOL might not come ask because they got a lot of stuff going on, right? We got ARPA cover subsidies, and they're still kind of focused on COVID. Okay, I'm going to be honest. However, you might have a participant that asks, right? I'm going to be honest and just saying, that with mental health treatment, a lot of that is very necessary. And so if someone hits a roadblock on that, there are national organizations that kind of let them know what their rights are. And you might see a request for this analysis if someone gets a claim denied, right? And so then you could run into it. And I think that's more likely than necessarily having the DOL approach you about it. But also keep in mind that if you're just one of those companies where the DOL opens an investigation on anything else, they'll also ask for this, right? And so that's why I said I think it's important to at least have the conversation with your insurer about how you're going to get this done, because if somebody does ask, you need to produce it.
And then, thank you. And then if you could maybe identify one or two red flag type situations. So if you were looking at a plan design yourself and you were, oh, I need to look into this a little bit more.
Yeah, I think that the four that Diane mentioned, that the DOL is going to be looking at it, that pre-authorization piece, I think honestly is the biggest one that I have seen as it pertains to non-quantitative treatment limitations. And it's kind of interesting because it almost seems like it's a quantitative treatment limitation until you really read what it says. So what the plan document will say is after 5 visits, after 5 mental health visits, you have to get pre-authorization for the 6th, right? And to you hear that 5 visits and you think, oh, maybe that's quantitative, except it's not. It's actually that a pre-authorization requirement was entered. And when you see something like that, think about the fact that people go to the doctor, let's say, to address their diabetes 8 or 9 or 10 or 12 times a year, and they may never hit that pre-authorization requirement, right? And so if you see, let's say, something like that where there's a pre-authorization requirement in place, that is a big red flag. And I think that is one of the biggest ones, which is why it's one of the 4 that the DOL addressed.
It is interesting because we did get a question about the integration of EAPs with a medical plan. And sometimes you would have that situation where when you go to the EAP, you would just get a referral to a provider. But when it's integrated with the medical plan and that provider is also on the network with the medical, then you might have to answer additional questions in order to get it approved under the medical.
That's actually also a good example. And I think it also shows kind of how difficult this can be because, yeah, when you have that EAP that is integrated, then yeah, those requirements under Mapia are also going to apply. And a lot of us don't look at the EAP as being a part of our plan in that way. And so that's a very good example.
Yeah, and then we got a question about if our plan doesn't offer mental health care at all. That's a tough one because if you are fully insured, most states mandate some sort of coverage for fully insured plans. Even if you're a small group, that's one of the 10 categories of essential health benefits for a small fully insured plan. So yeah, we would want to look at that a little bit more if you're saying you don't cover any mental health, because there's a lot of state issues, especially if you're fully insured there.
Right.
Well, we did get more questions right when I said at the end, of course. What is the time frame again if I got a request from a participant? Do we know what point we would have to?
Did we find that, Diane, how long they have to actually provide it?
Right. I did not find it definitively. I think what the regulation does provide specifically in that if the DOL provides or finds some sort of potential violation, that the employer has an additional 45 days to cure. So they would have at least 45 days to respond if you, it would appear, you would utilize that.
Yeah, generally when people ask you for stuff, 30 to 60 days is the max. So so you couldn't just be like, we'll get it to you, and then 6 months later be like, here it is. That's not, because think about it from the standpoint that if somebody's asking you for it, its chances are because they have a denial or on their hands, or they have a benefit that they need to get, right? And so obviously pushing that out for months and months is not going to be within the spirit of the law, right?
Makes sense because plain document requests are 30 and a lot of claims determinations are 45 days.
Right.
Okay. Yeah, I think the other questions are just, confirmation that it's overwhelming and not really sure what questions to ask. But this is helpful because it provides a base on which to frame everything. It's like, okay, well, check with my carrier or TPA first. If they're not that helpful or don't have anything, maybe I need to go to outside counsel, figure this out. So thank you. This has been really good.
Thank you. I will say that one of the questions I got before this call was this idea of whether or not there's a tool that helps you do this.
Yeah.
And I have to be clear, not quite, right? So, like on the quantitative treatment limitation side, it was actually easy to create a tool because, like I said, that's a lot of math, right? And you can take data that you have that's very specific with numbers and you can plug it in and find out if the substantially all or predominant tests are met, right? On the non quantitative treatment limitation side, it's not the same, right? Like, first, you'd have to find the non quantitative treatment limitations, and then you just have to determine whether or not they can be imposed at all, right? And so it's not as easy to create a tool. And so I don't know that there's a lot of entities out there that are going to have that. You're really going to be working with your insurer to get that analysis from them, more than likely.
Yeah, I love that because it's not like you're entering in, oh, my copays are this number, and then there's some
Right.
kind of formula.
Right. Exactly. So those were good questions. Leanne, I'm going to turn it over to you to close us on out. And thank you, everybody, for participating today.
Thank you.
Thanks.
Thank, thank you, Diane, Beth, and Jill, for sharing your valuable time and your expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the Get Wise Wednesdays emails and on the NFP website. If there are any portions of this call that you may have missed, by Friday you will receive an email with a link to the full recording, and the PowerPoint slides used during today's presentation will be shared in that same email. Lastly, for those of you that may have joined our call a little later and who are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In the next 24 hours, I will email the program ID number for you to record and submit to the HR Certification Institute. This credit will only be available to those who listen to the actual webinar, not to those listening to the recording later. Additionally, you must remain on the call for the entirety of the webinar to be eligible for the credit. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey as it lets us know what topics are important to our listeners and helps us to make our education program as current and relevant as possible. That concludes the webinar for today. Thank you all for joining us and have a great day.